Hello and welcome. Today, we are digging into a really fascinating and honestly crucial corner of Scots law. It's all about time limits, but as you're about to see, not all legal clocks are built the same way, not by a long shot. So let me ask you this. Just imagine for a second you've got a legal claim, a solid one, but you missed the deadline by one day. Just one. Is that it? Is your case totally done for before you even got started? Well, the answer, and this is what's so interesting, is maybe. It all hinges on which of two completely different legal stopwatches was ticking on your claim. One path might just offer a sliver of hope, while the other means your right has literally vanished into thin air. Okay, let's get into the weeds here. Both of these concepts, prescription and limitation, come from the exact same piece of legislation, the Prescription and Limitation Scotland Act 1973. How wild is that? One law, but two fundamentally different philosophies on what happens when time runs out. And believe me, getting this right is absolutely critical. Confusing these two isn't just some academic slip-up. It could make you think you have time when you don't, or worse, make you give up when you might still have a chance. The difference has real, tangible consequences. So let's tackle the first one, and you could argue it's the more brutal of the two, prescription. This is the one where time is an absolute, unforgiving force. See, prescription doesn't just block your path to the courthouse, it completely annihilates the right itself. It literally ceases to exist in the eyes of the law. Think of it like a piece of paper turning to dust. There's just nothing left to hold, nothing left to enforce. Now, for most of the claims you'd run into, we're talking things like unpaid debts or someone breaching a contract. This period is 5 years. It's what lawyers call the short negative prescription. Let 5 years pass without any action, and that legal obligation is just wiped from existence. And this really says it all, doesn't it? The finality here is total. It's not just that you can't sue for the money anymore, it's that legally speaking, the debt itself is gone, poofed. So here's the absolute bottom line. With prescription, there is no safety net. No judge, no matter how sympathetic, has the power to grant an extension or make an exception. Once that 5-year clock hits zero, that's it. The right is gone, forever. End of story. Okay, now let's switch gears and look at our second concept, limitation. And this paints a completely different picture. If prescription is a vanishing act, limitation is much more like a locked door. You see, with limitation, the right itself actually survives. It still exists. What the law does is it just bars the court from hearing the case. The right is still there. On the other side of that locked door, you just can't get a court to open it for you. Well, usually. And this idea applies to a whole different category of cases, most importantly, things like personal injury claims and defamation cases. The time limit here is shorter. It's 3 years from the date of the incident, or from what's called the date of knowledge, which is basically when you first realized you had a claim. But here is the massive difference. There might be a key to that locked door. Under Section 19A of the Act, a judge actually has the power, the discretion, to let a late claim go ahead if they think it would be fair or equitable to do so. Now, it's a really high bar, and judges use this power very carefully. But the point is, it exists, and that possibility changes everything. So you've got one concept that completely destroys the right and another that just bars you from taking action on it. Let's put them side by side, because seeing them together really hammers home why this isn't just legal nitpicking, it's vital. And this table just lays it out perfectly. Look at prescription, its effect, it extinguishes the right. The finality, absolutely final. And judicial discretion, nope, none. Now look at limitation, it only bars the court action, which means exceptions are possible, because yes, a judge has discretion. But check this out. Here's a really fascinating twist where these two ideas actually overlap. A personal injury claim has that 3-year limitation period, right? And during that time, a judge has discretion. But it's also subject to a 20-year long negative prescription. This thing acts as an absolute final backstop. So even if a judge wanted to help you out on year 21, they couldn't. Because after 20 years, the right itself has been prescribed and is gone forever. Okay. So let's bring all this back down to earth. What's the practical takeaway here? Why does any of this complex legal stuff matter to you? Well, it really boils down to this simple mental flowchart. The first thing you have to know is what kind of claim you have, because that tells you which clock is ticking. Is it about a debt or a contract? Uh-oh, you're on that unforgiving 5-year prescription clock. Is it a personal injury claim? Okay, you're on the 3-year limitation clock, which has that tiny but crucial window for a possible exception. I think this sums it up perfectly. For a right that can prescribe, being late is absolutely fatal. There's no coming back. For a right subject to limitation, being late is still very, very serious and probably fatal, but it isn't automatically absolutely the end of the road. And that really leaves us with this final thought to chew on. In the world of legal deadlines, especially in Scotland, the first and most important question you have to ask yourself isn't, am I right or can I win? It's something much more fundamental. In the eyes of the law, do I still have a right to even ask the question?